In this installment of Washington Legal Foundation's Legally Brief, David Seid, a partner with the law firm Curtis, Millay, Prevost, Colt, and Mosley, and a former assistant United States attorney, evaluates the risks of providing civil enforcement agencies such as SEC and CFTC with criminal prosecutorial authority.
Since the recent appointment of Mary Shapiro to head the Securities and Exchange Commission, the pace of SEC civil enforcement cases have picked up. But some have argued that the SEC and other civil agencies should be granted more authority, criminal authority. That proposal, floated by two commissioners in recent months, likely faces many hurdles and deserves much closer scrutiny. Let's start with some background. On March 18th of 2009, SEC Commissioner Louis Aguilar made a number of proposals intended to streamline and intensify the SEC's enforcement process. Included was the suggestion that the SEC should have the power to bring criminal cases as a standby or backup remedy, limited to cases where the Department of Justice has declined to do so. Commissioner Aguilar's position followed on the heels of a similar proposal made about a month earlier by CFTC Commissioner Bart Chilton. In a February 2009 speech, he pointed to the complexity of the Commodities Exchange Act cases and suggested that the CFTC, too, should be granted standby criminal authority in cases where the Department of Justice declines to act. Now, some in Congress have also expressed interest in the idea. For instance, there's a bill pending in Congress called the Derivatives Market Transparency and Accountability Act of 2009, which would vest standby criminal authority in the CFTC in cases where the Attorney General declined to act. Now, what is driving these proposals? First and foremost, it seems to be a decline in attention being devoted to criminal cases on the financial fraud front. For instance, federal court statistics show there were only 66 criminal cases brought for securities and exchange fraud in 2008, down from 101 cases in 2005. And a recent report issued by the General Accountability Office reveals that the number of SEC investigative attorneys have fallen by over 10% between 2004 and 2008. Now, those statistics will likely soon change, given that the SEC and the Department of Justice are now under new management. But giving civil agency criminal authority is not the answer. Putting aside the bureaucratic turf wars that would inevitably arise, awarding criminal authority is an extreme departure from the long-standing division between criminal and civil federal authorities. One example of the line-blurring problems likely to arise is illustrated from a case in 1979 called Dresser Industries versus United States. In that case, Dresser, a publicly traded company, conducted an internal investigation to determine whether its employees had made questionable foreign payments. Dresser agreed to turn over the results of its internal investigation to the SEC, provided that the SEC agreed to keep the internal investigation confidential. But the SEC turned over the internal investigation to the Department of Justice for criminal prosecution, and Dresser argued that it had received criminal immunity from the SEC by nature of the SEC's agreement. Not so, said the Fifth Circuit. The Fifth Circuit in that case said only the Department of Justice has the authority to confer criminal immunity. The Department of Justice was not a party to the agreement between Dresser and the SEC, and so the SEC could not confer criminal authority, notwithstanding whatever agreements it had entered into. Well, that division of labor would fall under the new regime that is being proposed by Commissioners Aguilar and Chilton. And many questions arise. What kind of pretrial criminal procedure would civil regulators apply? Could they or should they convene grand juries? How will civil regulators handle differing proof issues between civil and criminal cases? What about the risks that subjects or targets of investigations will face? regulated financial entities can't afford to be indicted. Yet, under this proposal, regulated financial entities will be faced with the leverage of criminal indictment if civil agencies are vested with criminal authority. There's also a problem of simply vesting too much authority with civil agencies. Now, our courts have been especially careful to manifest concerns about too close coordination between civil and criminal authorities, and this has come up in parallel proceeding cases. Now, civil and criminal authorities can coordinate on cases, but their conduct can cross the line and become impermissible government behavior when one agency's powers are used to achieve another agency's goals. Given that reality, given those concerns, whether criminal and civil authorities should be merged together is clearly an area that is likely to be the source of great controversy in weeks and months to come. And one would argue that the chances of the proposal actually taking shape faces formidable hurdles. Yet we are in the midst of the most serious financial crisis in generations. And as a consequence of that, financial reform, regulatory reform is at the tops of everyone's agenda. And because of that, it bodes well for all of us to pay special attention to this area. But secondarily, the fact that the proposal is being debated suggests perhaps a secondary laudable goal, arguably, which is to apply more resources in this area.